Just call the case. People versus Dolores Strickland. Yeah, relax. Go ahead, have a seat.
Ready, Judge. Torshell Feaster, Assistant Public Defender, appearing on behalf of Ms. Dolores Strickland. Ms. Strickland, please state your name for the record.
230 times Dolores Strickland.
Thank you, Judge. I have had many conversations with Ms. Strickland, and we were working with the people, with Ms. Tana, to try to resolve this matter. Ms. Strickland had a particular offer she wanted requested. I asked Ms. Tana for that.
You asked?
Ms. Tana.
How'd that go?
She was not willing
to
give Ms. Strickland the offer that she wanted. Then I sent Ms. Tanha the mitigation letter just to make sure she had it, because Ms. Strickland wanted you to have it and Ms. Tanha to have it. I told her this was not the point for Your Honor to have a mitigation letter, but I did make sure Ms. Tanha had it. And you're asking for another adjournment so Ms. Tanha can consider the offer in light of the mitigation letter that I have made sure she had per Ms. Strickland's request.
So, do we have the?
And also, can we do that as soon as possible? Because I've been in here, Your Honor, 230 days today, and I've got absolutely nowhere. And I also sent you the mitigation letter and a letter in the mail just recently. So you'll probably get that too.
Okay. I know you've been in a while, but I also have 3 cases. So that may be part of the problem.
Altogether, from what I understand.
If I might, Judge, Ms. Strickland is hoping for a resolution that will not include any type of probation.
Oh.
And that is not what is being offered at this time. And that is going to possibly be a hang-up to resolve this matter.
And Your Honor, I told him that I would maybe consider it. It depends on how long it would be. But however, I do have family in Florida, that Tallahassee, the hurricane, things like that I really need to get out to see if they're even alive or what happened to them, because I can't find nothing out in here. And I talk to them through Messenger. That's the way I stay in touch with my family. And I know they got hit. I just don't know how hard. And I can't get no information because the only person that I have here is my ex of 15 years and my other kids that, I don't have their number right now either, because I cannot get to their number, and I do not have phone, which I need to ask Your Honor, can I get my phone privileges back on, please?
I believe they were restricted because she had contacted.
Because she violated a condition of bond, so I revoked it.
Correct.
I was already punished for that, Your Honor, because he had them block his number. So that should have no problem of me calling my brother and trying to get help from him, or, contact him, because that's who I was contacting. I wasn't contacting my ex.
Okay, Strickland. Now, a lot of these requests that you're making.
It's because I got nowhere.
Okay, listen. You need to talk with your attorney about them.
Your Honor, I have.
Do you listen to your attorney as well as you're listening to me? That means not at all.
I got mental issues that just I'm overwhelmed, very much so, Your Honor, but go ahead.
Thank you. Talk to your attorney about these issues. He'll talk to the prosecutor. They'll see what can possibly be worked out, if anything can be worked out. I'm not reinstating your phone privileges. You violated that condition of bond. That will continue revoked.
Then I'll just continue.
Okay.
Sorry, Judge. If we could have an adjournment so that Ms. Tana and I'm bad with names.
Ms. Rizmersky.
Ms. Rizmersky. I knew the first name. Ms. Rizmersky could consider Ms. Strickland's.
How much time will it take for them?
We only need a week or two, Judge.
A week, please, Your Honor. A week. Let's speed this up, Your Honor. I'm trying to. If you just read my mitigation letter, Your Honor, you can find out why.
Ma'am, that's a problem. You keep doing things that your attorney says it's not the appropriate time. When I get that letter, comes into my office, I'm going to tell you, I am not going to review it because it's not appropriate for me to see that.
Well, why
If
am
you
I
listen
here
to
for?
your attorney, maybe this would go a little bit smoother.
Your Honor, my attorney's not telling me what I need to know. I'm lost.
No, your
That's why
attorney's
I'm
not
so-
telling you what you want to hear. He's telling you what you need to know. You're just not listening, like you're not listening to me. These matters are adjourned to the 17th, 9 a.m. Bond continued. Thank you.
Thank you, Judge.
Here, you can do this.
Thank you, Judge.
I'd like to say the same to you. Court does call.
Good morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Assistant Public Defender Jay Bellinger.
Really?
I know.
Bellinger?
I don't have any t-shirts today for you.
It's okay. All right. Permission to practice is granted.
Thank you, Your Honor. Your name for the record.
David Stevenson White.
Oh, you didn't get her name. What's your name again?
David Stevenson White.
No, not you.
Oh,
I know what your name is. I got your file. You're in green. I got you.
yeah, all them.
All right. Your
Yeah.
name.
Hannah Mackey.
Got it? Hello.
Makki.
Have you appeared before me before?
Not before you.
I
No.
didn't think so.
You know,
That's why we don't have any. Where are you from?
Where?
Where? That's a question. Yes.
Like
where you're from, just say.
Michigan,
Okay. That's a good start. What part of Michigan?
Ann Arbor.
You're from Ann Arbor?
Yes.
Where'd you go to high school?
Divine Child in Dearborn.
Oh. Couldn't stay here.
Oh, that's a good school.
Where'd you go to undergrad?
Michigan.
Where are you in law school now?
It's just gonna get worse every time you ask. Michigan State.
Should have said no.
Yeah. Probably should have just not told me the truth. Okay. It's okay. We got you. We'll talk slow. All right. Sorry. Had to take the shot. What are we doing in this case?
Your Honor, Mr. Stevenson is prepared to waive his right to a preliminary examination.
Sir, is that correct? After all that?
Yes.
Okay. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Sorry.
And you understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right.
Your Honor, we waive formal reading of the complaint.
Whoa.
Acknowledge receipt in my client's.
Whoa. How'd she just do that? Bellinger.
Yes, Your Honor.
How'd she just started jumping in?
Well, Your Honor.
Okay. All right.
I was told when you look up at me to say it, so.
Is that what Bellinger said? Is that what he said? Oh, don't listen to what he says. When he looks at you, do something. Listen. Okay. Just slow down.
Okay.
Okay? People also waive their right. Yeah, they forgot that part. Who's?
He's looking at me.
I was like, am I in the middle of this?
No, you're good. No, you're good. It's the attorneys. They're out of control.
It's not my fault.
No, this is not your fault. The other part was.
Yes, Your Honor.
Do the people waive their right?
To a preliminary exam, absolutely.
Okay. Preliminary examination having been waived, defendant is bound over to circuit court on the single charge. Now I'll look at you. Go.
Your Honor, we waive formal reading of the complaint, acknowledge receipt, and my client will stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
October 22nd, 1:30 before this.
October 22nd, 2024, 1:30. Bond will continue. So you made it through. You're
I
good.
think
What?
I see Miss Conti today too, I think.
You do?
I believe.
Yeah,
If I'm
Well, good.
if I'm not mistaken.
Okay, well, good luck. All right, thank you. Take care.
Any information?
Yes.
Thank you.
Oh, is she? Don't be embarrassed. You're good. You're not? I would be. All right, so. Court does call the case.
After 230 long days locked behind bars, Dolores Strickland finally stood before the judge, exhausted, emotional, and visibly begging for movement in a case that had left her completely stranded. Her public defender explained that multiple negotiations had already failed, including a special plea deal Dolores personally requested, and even a mitigation letter meant to humanize her suffering, but prosecutors refused to budge. Dolores didn't hold back, telling the court she was desperate to reach her family in hurricane-struck Florida, terrified she might have lost loved ones, trapped in jail with no phone, no answers, and no way to contact anyone except an ex she hadn't spoken to in 15 years. She pleaded for her phone privileges to be restored, insisting she only tried contacting her brother for help, but the judge shut that down instantly, reminding her she violated bond conditions and would stay cut off. As Dolores spiraled emotionally, admitting she was overwhelmed and struggling with mental health, the judge delivered a brutal reality check. She wasn't listening to her lawyer. She wasn't listening to the court, and wanting things her way didn't change procedure. When Dolores begged the judge to read her mitigation letter directly, he refused flatly, explaining that doing so would be inappropriate and only hurt her case, then sharply told her that her attorney was telling her what she needed to hear. She just didn't like it. The tension in the room thickened as Dolores repeatedly claimed she had nowhere to go, no support system, no outside help, while the judge calmly reminded her he had 3 cases on his docket and couldn't bend the system for one defendant. With negotiations stalled and probation on the table, something Dolores clearly did not want, the judge adjourned the matter for another week, leaving her stuck in legal limbo, bond unchanged, freedom nowhere in sight. Then, without pause, the courtroom energy flipped completely as a nervous young law intern stepped forward, stumbling through procedure, prompting sarcastic humor from the judge as he grilled her about Michigan, law school, and courtroom protocol, turning her anxiety into an awkward public lesson in real time. Moments later, a second defendant quietly waived his preliminary hearing, barely saying a word as his fate was sealed in seconds, bound over to circuit court while formal charges moved forward like clockwork. And just like that, Dolores' emotional breakdown faded into background noise as the system marched on, proving once again that in this courtroom, desperation doesn't slow justice, personal suffering doesn't change timelines in chaos, and consequences exist side by side, where one woman fights for contact with her family, another attorney learns courtroom survival the hard way, and another defendant moves deeper into the criminal pipeline, all within the same brutal morning. Reminding everyone watching that once you're inside the system, it doesn't care how scared, lost, or overwhelmed you are. It keeps moving.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Don Lee.
All right. Hey, where are we on this case?
Thank you, Your Honor. This is a driver's license case and I have discussed this with Mr. Lee. He will be accepting the offer extended to plead to MCL 257.326.
So, Your Honor, I'd move to add count 2 of MCL 257.326, allowing an ineligible person to drive. If you accept that guilty plea to add count 2, I move to dismiss count 1.
Raise your hand. Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Don Lee.
This court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
On the date of February 10th, 2024, Michigan Road near Moon Road, Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court
Sorry.
will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
Just very briefly, Your Honor, Mr. Lee is asking that the court consider sentencing him to time served. I do acknowledge he wasn't arraigned on this case until September 19th and only has 9 days credit, albeit he was not being held on this case. Outside of that, I just leave it in the court's discretion.
Anything you want to say, Mr. Lee?
And I just wanted to get this over with and keep him going.
You come back on that other thing tomorrow. Is it tomorrow?
He's up on the 8th.
On the 8th.
For exam, Your Honor.
Just trying to recall, when I put you into custody, did we set an exam? Is that what we
Yes,
did?
exam is on the 8th.
Before me?
No, it's before Judge Burke.
Okay. All right, I'll take a look at that because all right.
I think I have the file up, Your Honor. Did the court have a question I could help with?
Well, I put him into custody, but I know I told him I was going to take a look at that on the remand into custody on it because it came as a result of a police report regarding something else happening.
Yes, it was because there is a new case that is coming down the pipe. To which Ms. Blanche said that the warrant was going to be authorized that day, I believe. Mr. Lee advises, and I don't see anything to contradict that, he hasn't been arraigned on that new charge yet, however, but the 2 ones that he was in front of Your Honor for last week for PCC are set for exam, both cases in front of Judge Burke on October 8th. He's represented by Sam Bernstein in one and the public defenders in the other.
Okay, so my question becomes all right, that's right. That refreshes my memory. Where's that other case? Because the thing, I'm not asking.
Okay.
You don't know.
I know I ain't been arraigned on it.
No, I know, but I'm trying because
So, Your Honor.
I don't know. Did I change his bond on? I did change his bond on that. He was supposed to then be arraigned on the other case, but that case was supposed to get. There was supposed to be a timing on that case to get down. So I remanded him. He was going to be held on these cases, on the ones that are set for exam. And then that other case was going to come down, expected that he might be in on that case. But if that case hasn't come down, I'm not going to be very happy right now.
Yes, to my understanding, Your Honor, he has not been arraigned on that new case, but the 2 cases that are already set for exam in front of Judge Burke, currently his bond is $15,000 on each of those cases.
Correct. I get that. What?
You raised it was a PI bond and you raised it up.
I put it up because of the representation of these other cases, but those other cases were supposed. What's the status of that other case?
Your Honor, Ashley Lottie for the people on behalf of talk about these other matters. So if I'm reading this correctly, other cases was a resisting and obstructing case that was supposed to be coming down. Is that, Ms. Page, is that correct?
I don't think that was, it was involving a car accident and some other stuff.
I don't know the exact charges that were to be authorized, but I know the incident date was before the ones that are currently set for exam.
Right.
That being said, I
know.
Yeah.
Listen, where is that case? Because my problem here is that, and Mr. Lee is certainly not always the most cooperative person in the world, and he knows that. But he got remanded because his other case was coming down.
Correct.
And so I'm trying to, and I think there was a representation that it had been signed off or it was someplace, and the expectation was that case was going to get sworn out. While in custody, he'd be arraigned. And then there would be, based upon the facts of that case, a bond set that was likely or may have, I won't say, I can't say for sure, may have kept him in custody, which is why I did what I did.
That was my understanding, Your Honor.
I just need a little bit more information.
Go look.
So I want to understand, Mr. Lee was last before the court for PCCs. The court is saying on the 26th or the 18th.
I think it was a week ago, wasn't it? I think it was.
The 20.
I think it was the 26th. He was before me.
I have some help helping right now. So the new case, which does appear to be related to fleeing and eluding charges, dated incident 8/29/9/20 to 9/2. It appears that case was authorized, signed by my office on 9/26. And I don't see.
That's what was indicated to the court on the record, that it was signed off on 9/26. But then there was a representation that it was going to get sworn to. It was signed off by your office. I think that's what was represented to me. It was going to get sworn to so that Mr. Lee could be arraigned on it.
My understanding is that Magistrate Fink signed that case on September 30th. It is likely,
well, then why hasn't he been arraigned?
I'm not sure, Your Honor. It may be in a stack of things that are waiting to be entered. That's been happening.
Oh,
I don't
know. No, that will not happen. Miss.
Can you tell me what the jurisdiction is?
Yes.
It's not.
It's Ypsilanti City. It's Ypsilanti City.
It's a city case.
No,
It's a sheriff's office. It's a sheriff's office arrest that occurred in Ypsilanti City.
I show with the 14B.
Okay, so it's on the line. It said the swear out was on the 30th. Yeah.
I have a police officer.
Oh, really?
Yes, that helps.
So, whoa. Is that what the log notes indicate?
Yes,
So there are no charges.
correct. It says court does not find probable cause.
Okay. Okay. Just hold. Hold. That's what it says?
Yes.
So there is no case.
Can I confirm the police report number for that?
Mr. Lee, that's what we're gonna do. I'm gonna have them take you back.
Okay.
And we'll try to figure everything out, have you brought back out, and I'll do what I gotta do.
Okay, thank you.
All right.
Thank you, Your Honor. Assistant Public Defender Natalie Pate, with and on behalf of Mr. Lee, who stands to my right.
I still have to sentence him on the driving well or the operating well. So we've taken a look at it. That complaint that I put Mr. in custody on there was no probable cause found. And so that was not done. And I'm going to say this. They knew the reason. Mr. Lee understood what I was doing and putting me into custody. The prosecutor's office, I think, given the representation made to this court, was under an obligation to contact this court immediately upon notification that those charges were not brought, knowing that affected Mr. Lee's liberty. And I'm not happy that I wasn't contacted at all. Anything you want to say before I sentence him on his misdemeanor?
Nothing further, Your Honor. I would just reiterate his request be sentenced to time served on that misdemeanor.
Fines and costs of $250. Those fines and costs are waived in their entirety. 90 days suspended on that case. With reference to his felony matters, those will continue to preliminary examination on October 8th before Judge Burke. Bond on those cases, both will be set at personal recovery.
Just what you said on the previous conditions that were impacted
The conditions will remain. They never left.
Thank you.
It's just they took his liberty on something that didn't get authorized. You're going to be free to go.
So I'm going home today?
You're going to be let out, sir.
Thank you.
Thank you very much, Your Honor.
Court's going to stand in recess.
All rise. Thank you, Your Honor.
You're welcome.
All rise. The 14th District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Jay said attempts to preside.
Has the state prosecutor left?
I think so.
She needs to get back in here because I'm going back on the record on Mr. Lee. I don't know who else has that case. You may be seated, folks. Yes. At 1 o'clock?
Yeah, she has.
I want her here because I need a message gotten to that office right away. Court is recalling the cases of the people versus Don Lee, both his felonies and his misdemeanor cases.
Good morning again, Your Honor. Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Lee.
I'm going to waive Mr. Lee's appearance because they took him down so he could be processed out immediately. But I want to make a record clear and know, and I realize, Ms. Lundy, you were not the one involved, but I am more than livid right now because this case, we went back and checked our records. Mr. Lee was taken into custody on the people's representation regarding the previous case. I took him into custody at 11:43 a.m. on June 26th. After having him wait here in court, I took him into custody on that date, and it's important, at 11:43 a.m. on the 26th. There was an attempt to swear out that case that was done before Magistrate Fink less than an hour later at 12:31 p.m., where the magistrate did not find probable cause. And this court was not informed. Mr. Lee was in custody. It was another attempt made to swear out that complaint on the 30th. Again, no probable cause. It is inexcusable that the prosecutor on their representations had this court act that deprived Mr. Lee of his liberty for 7 days. Inexcusable. So, Ms. Lundy, again, while you are not the person that was involved in this, but has done, I will expect a call from Ms. Burton Harris regarding this matter.
Yes, Your Honor.
Today.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
What started as a simple driver's license misdemeanor instantly turned into a full courtroom explosion when Donley stood before the judge expecting a quick plea deal, only for the entire system to unravel in real time. Lee calmly admitted guilt to allowing an ineligible driver to operate his vehicle, a charge punishable by just 90 days, and told the court he simply wanted to get this over with. But seconds later, everything spiraled. The judge suddenly realized Lee had been sitting in jail not because of this case, but because prosecutors had claimed a new felony case was coming down the pipe. That case had never existed. The judge dug deeper, discovering that Lee had been remanded into custody based purely on prosecutor representations that charges were imminent, only to find out that 2 separate attempts to swear out the alleged felony had already failed for lack of probable cause, and nobody bothered to tell the court. As confusion turned into fury, the judge openly admitted he was not happy, then escalated to visibly furious, declaring on the record that Lee had been illegally deprived of his liberty for 7 days over a case that never even cleared a magistrate. The courtroom went silent as the judge blasted the prosecutor's office for staying quiet while a man sat behind bars, calling the situation inexcusable and demanding supervisors be contacted immediately. Lee, who moments earlier expected a routine sentence, suddenly found himself unexpectedly freed, fines waived, 90 days suspended, bond reinstated, and escorted out after being wrongfully jailed over phantom charges. But the judge wasn't finished. He recalled the case, dragged prosecutors back into court, and unleashed a second wave of fury, detailing timestamps down to the minute, explaining how Lee was taken into Custody at 11:43 a.m. How probable? Because was denied less than an hour later. How another attempt failed days afterward, yet Lee remained locked up anyway. The judge made it brutally clear this wasn't a clerical mistake. This was a complete breakdown of accountability that stole a man's freedom for an entire week. He demanded direct calls to senior prosecutors, labeled the conduct unacceptable, and put the entire office on notice, all while Lee was being processed out of jail. In a matter of minutes, a low-level traffic plea turned into a judicial reckoning, exposing how one false assumption, one silent prosecutor, and one unchecked system decision nearly destroyed someone's liberty, proving once again that in this courtroom, freedom can disappear faster than paperwork, and justice only arrives after damage is already done.